A number of factors such as national origin and immigration, language, military status, and appearance, and weight might lead to unlawful discrimination in employment. Let's take a look. In addition to Title VII protections, a number of federal laws have been enacted to address these forms of discrimination. Many of these laws were passed in response to improper company decisions that resulted in unfair treatment of applicants and employees. The Immigration Reform and Control Act, or IRCA, enacted in 1986, requires that employers verify the employment eligibility status of all employees, while not discriminating because of national origin or ethnic background. Employers may not knowingly hire unauthorized workers for employment in the United States. Within the first 3 days of employment, each employee must complete an employment eligibility verification form, commonly called the I-9, and provide documents proving that he or she is legally authorized to work in the United States. The employer is required to inspect the documents and maintain records for all new hires. As the diversity of the workforce increases, more employees have language skills in addition to English. Interestingly, some employers have attempted to restrict the use of foreign languages at work, while other employers have recognized that bilingual employees have valuable skills. There's been much debate on both sides of this issue. EEOC guidelines have not been entirely clear about how companies should address these language issues in the workplace. The employment rights of military veterans and reservists have been addressed in several laws. The two most important are the Vietnam-era Veterans Readjustment Assistance Act of 1974 and the Uniformed Services Employment and Reemployment Rights Act, or ERISA, of 1994. Under the former, federal contractors are supposed to provide employment opportunities for veterans based on percentage benchmarks that are not related to quotas. Under the latter, employees are required to notify their employers of military service obligations. Employers must then give employees serving in the military leaves of absence protections under ERISA. Several EEOC cases have been filed concerning the physical appearance of employees. Court decisions consistently have allowed employers to set dress codes and appearance standards as long as they are applied uniformly. Also, employers should be cautious when enforcing dress standards for female employees whose religious practices prescribe appropriate and inappropriate dress and appearance standards. Some individuals have brought cases of employment discrimination based on height or weight. Employers must link any weight or height requirements to specific job functions. Complying with this complex array of regulations requires diligence and careful record keeping.